My lord, page 4 to 15,
Of
my submissions, my lord. Page 6 to 15, I'm sorry. I
actually,
have given, my lords,
your formulation is best brought out in page 11,
yes, my lord.
para 44.
Yes, my lord.
Those 4 points.
My lord,
What I
may I just read, my lord, for your, my lord, so that I make myself more clear. The world religions have shaped the history of marriage and family and continue to form the basis of marriage as an essentially religious concept. While it is correct that there is significant divergence between different faiths and their practices in relation to marriage, what must not be lost sight of is that there is more convergence than conflict in teachings, marriage, and family. All six major world religions overlap on the following attributes of marriage as identity. Then I have given the source. First, each of these religious traditions confirms marriage as a vital and valuable institution and practice that lies at the heart of the family and at the foundation of broader society. Second, each tradition recognizes that marriage has inherent goods that lie beyond the preferences of the couple. One fundamental good of marriage emphasized by Judaism, Christianity, Hinduism, and Confucianism is that the husband and wife complete each other. Indeed, they are transformed through marriage into a new person, a new one, fresh reality. Another fundamental good of marriage is the procreation and nature of children. Lord, this is not an archaic concept. Special Marriage Act uses the word procreation. Children are sacred gifts to a married couple who carry forth not only the family name, lineage, and property, but also the community's religion, culture, and language. All these religions thus see a close relation between marriage and children, just as they saw a close relation, although not an identity, between marriage and sexual expression. And all these religions teach that stable marriages and families are essential to the well being of children. This is what Malot Kara says in the adoption. 2 years of stable relationship as husband and wife. Third, each tradition regards marriage as a special form of sacrament, promise, oath, or contract over any generic relationship, economic or social. It has a special, unique status, my lord. For Hindus, it is a sacrament. For Muslims, it's a sacred contract, but nonetheless a sacred contract. And across the faith, what is recognized as a marriage is between heterosexual couple. Fourth, each tradition eventually came to insist that marriage dependent in its essence on the mutual consent of the man and the woman. Even if the man and women are represented by parents or guardians during the contract negotiations, their own consent is essential to the validity of their marriage. Jewish, Hindu, Confucian, and Muslim writers came to this insight early in the development of marriage. The Christian tradition reached this insight canonically only in the 12th century, and Buddhism more recently still. Fifth, marriage is a concept that is deeply embedded as a union between two opposite sexes ordained by the religious text and practices specifically for the furtherance of society and the orderly influence between persons inhabiting the society and following specific religions. Now, your lordships have a variety of shades to be dealt with, variety of problems which are to be encountered, variety of religions and their personal laws, my lord, intermingling, and your lordships have an option on, in my respectful submission, possibly the only constitutionally permissible option to require the parliament or to wait for the parliament to do that. My lord, please now come to page 16. My lord, I am citing some judgments. I will not read all, but these are, my lord, some very illuminating judgments, my lord. At page 17. My lord, right
1-7.
1-7. It starts at 1-6. The title is Democratic Right of People to Regulate Themselves.
You
Lord,
said
we as a society has a right to regulate ourselves.
176.
okay.
Lord, PDF 25.
21 plus
21, my lord. PDF is 21, my lord. We as a society, my lord, govern who will be the components of that society, my lord, and that governance comes in, my lord, the elected representatives whom we decide, my lord, to elect. Now, please come, my lord, this Reynolds Rajmani judgment. I'll read only the highlighted part, my lord, so that I don't invest your lordship's more time. It cannot be denied that society is generally interested in maintaining the marriage bond and preserving the matrimonial state with a view to protecting societal stability, the family home, and the proper growth and happiness of children of the marriage. I'll skip the rest, underline portion. But although the grounds for divorce have been liberalized, they nevertheless continue to form an exception to the general principle favoring the continuation of the marital tie. In our opinion, when a legislative provision specifies the grounds on which divorce may be granted, they constitute the only conditions on which the court has jurisdiction to grant divorce. If grounds need to be added to those already specifically set forth in the legislation, that is the business of the legislature and not of the courts. Lord, please, Lord, see these, my Lord, in light of what I'm going to show. The structure of the Special Marriage Act would be, if it is redrafted the way petitioners have prayed for. Even the prayers are, my Lord, absolutely vague. I'll be able to demonstrate that. But first, my Lord, law on the point. 5. When therefore Section 10 of the Indian Divorce Act specifically sets forth the grounds on which a marriage may be dissolved, additional grounds cannot be included by the judicial construction of some other section unless that section plainly intends so at the foot. However, whether a provision for divorce by mutual consent should be included in the Indian Divorce Act is a matter of legislative policy. The courts cannot extend or enlarge legislative policy by adding a provision to the statute which was never enacted there. Therefore, I started by saying that marriage is a socio-legal institution. Its recognition is a matter of legislative policy. Then, my lord, Keshavanand Bharti, my lord, kindly allow me to read, my lord. This would guide, my lord, us throughout, my lord, the hearing of this case. How we construe the constitution in the context of the marriage being given the recognition, my lord. Underline portion. It cannot be denied that provisions of the constitution of other countries are designed for the political, social, and economic outlook of the people of those countries for whom they have been framed. The seed of the constitution is sown in a particular soil, and it is the nature and the quality of the soil and the climatic conditions prevalent there which will ensure its growth and determine the benefits which it confers on its people. We cannot plant the same seed in a different climate and in a different soil and expect the same growth and the same benefit therefrom. Law varies according to the requirements of time and place. Justice thus becomes a relative concept varying from society to society according to the social milieu and economic conditions prevailing therein. The problems which confront those courts in the background of the state of the society, the social and economic setup, the requirements of people with a totally different ethics, philosophy, temperament, and outlook, differentiate them from the problems and outlook which confront the courts in this country. It is not a case of shutting out light where they could profitably enlighten and benefit us. The concern is rather to safeguard against the possibility of being blinded by it. Lord, this takes us to, my Lord, the theory that ultimately societal acceptance is one of the considerations for recognition of any union. And that can be tested only in the legislature. And, my Lord, there is a beautiful passage I'll read, my Lord, from the American Supreme Court, which says that any recognition by the court does more harm to LGBTQ plus community than help them. Because then you are forcing something which should have come from within. That's the logic, my Lord, of the Honorable Supreme Court. Now, my Lord, A.K. Roy, my Lord, 5-judge bench. I'll read, my Lord, the highlighted part. but we cannot transplant in the Indian context and conditions principles which took birth in other soils without a careful examination of their relevance to the interpretation of our constitution. No two constitutions are alike, for it is not mere words that make a constitution. It is the history of the people which lends color and meaning to its constitution. Lord, we cannot forget the historical background and the anthropological background, my Lord, which eventually resulted into creation of an institution called marriage across faiths, across religion. Now, my Lord, your lordships have seen, but my Lord, Justice Cardozo, my Lord, a little hard-hitting, my Lord, word, but my Lord, it really, my Lord, I would wish, my Lord, to place it. When they say that all we know want is a recognition, all we want is the confirmation of our right. The judge, even when he is free, is still not wholly free. He is not to innovate at pleasure. He is not a knight errant roaming at will in pursuit of his
Nature of
own
the judicial
ideal
process.
of beauty. I'm sorry.
It's the nature of the judicial process
Process.
you're quoting from.
That's correct. That's correct, Manoj. But Manoj, only few words I wanted to highlight, Manoj. Not the first part, which is slightly, Manoj, a little more harsher, Manoj. But thereafter, he is to draw his inspiration from the consecrated principles, and this is important. He is not to yield to spasmodic sentiment, to vague and unregulated benevolence. That's what, my Lord, I am driving at. The class with which, my Lord, your lordships are dealing is an unidentifiable class. They have their class specific problems. It would be completely, my Lord, a vague declaration, if at all it is to be made, without, my Lord, conceiving the problems they would be creating, my Lord. The mere declaration would continue. He is to exercise a discretion informed by tradition, methodized by analogy, disciplined by system, and subordinate to the primordial necessity of order in the social life.
Primordial.
I'm sorry, primordial.
I think our own Justice Patanjali Shastri has put it all in that one short paragraph in VG Rao. Everything that is on reasonableness and
Yes,
what is the
yes,
role of the court.
yes. Lord, kindly come to, my Lord, para 74, para 73, 74, and 75. This would be relevant, my Lord, for my purpose, because I'm going to, my Lord, rely upon Obergefell, Windsor, and, my Lord, their dissent. A beautiful dissent, because for us, both, my Lord, majority, minority, both are having persuasive value. It was a thin majority of 5 versus 4. But numerically, yes, majority, my Lord. Dissent is a dissent, but, my Lord, which would really assist your lordships. Now, your lordships may kindly see the landmark dissent of Justice Oliver Holmes in Lochner versus New York, which criticized the majority of the court for becoming a super legislature by inventing a liberty of contract theory, thereby enforcing its particular laissez-faire economic philosophy, is still remembered as a remarkable piece of judicial foresight. My Lord, then I have cited, my Lord, this judgment with a reason. My Lord, please allow me to cite Daybright Lighting. I'll just read, my Lord, the highlighted part.
Yes.
Our recent decisions make plain that we do not sit as a super legislature to weigh the wisdom of legislation, nor to decide whether the policy which it expresses offends the public welfare. Lord, 75, and before I, my Lord, read that, my Lord, I would like to, my Lord, just paraphrase it. Specifically, the dissent of Justice Holmes came to be fully accepted in Ferguson versus Krupa and continues to be the law of America till date. Interestingly, the dissent in both same-sex marriage cases in the American Supreme Court in Obergefell versus Hodge and United States versus Windsor blame the majority for committing the same mistake it did in Lochner suit. I'll read, my lord, and thereafter what happened after, my lord, this Obergefell judgment in Dobbs. This is doubted. Now, your lordships may, my lord, kindly directly come to, my lord. My lord, rest of the judgments are same, that your lordships would not, my lord, as a prudence and as a policy, substitute the wisdom of the legislature. But, my lord, kindly come to page 23, that is, my lord, 27 PDF. Only the highlighted part. Your lordship gets, my lord Justice Narsingh. Lord, page 23, PDF 27, my lord Justice Bhatt and Justice Kaul, my lord.
Yes.
Read the highlighted part. The power of the court to legislate is strictly limited. Judges ought to remember that their office is just decree and not just dere, to interpret law and not to make law or give law. Chief Justice Chandrachud, my lord, this can be, my lord, said now, my lord, that's my request. Chief Justice Chandrachud can say this, my lord, in the present judgment, my lord, on the lighter side, my lord. Chief Justice Chandrachud, speaking for a constitution bench in Gurbakh Singh, CBI versus State of Punjab, has clearly pointed out the limited powers of the court to make laws in construing the provisions of the statutes. The learned Chief Justice has observed the true question is whether by a process of construction, the amplitude of judicial discretion which is given to the High Court and the Court of Session to impose such conditions as they may think fit while granting anticipatory bail should be cut down by reading into the statute conditions which are not to be found therein. Our answer clearly and emphatically is in the negative. Nothing more can be read into the statute. Then, my lord, again the learned Chief Justice warned, judges have to decide cases as they come before them, mindful of the need to keep passions and prejudices out of their decisions. And it will be strange if, by employing judicial artifices and techniques, we cut down the discretion so wisely conferred upon the courts by devising a formula which will confine the power to grant anticipatory bail within a straitjacket. Therefore, even if we were to frame a code for granting of anticipatory bail, which really is the business of the legislature, it can at best furnish broad guidelines and cannot compel blind adherence. The court, by its very nature, are most ill-suited to undertake the task of legislating. There is no machinery for the court to ascertain the conditions of the people and their requirements and to make laws that would be most appropriate. Further, two judges may think that a particular law would be desirable to meet the requirements, whereas another two judges may most profoundly differ from the conclusions arrived at by two judges. Conscious of these handicaps, the law requires that even an amendment of the Supreme Court rules, which govern the procedure to be adopted by it for regulating its work, can only be effected by the whole court sitting and deciding. Lord, the court puts a word of caution that though, my lord, one of the finest, my lord, intellectual brains of the country would be deciding this, but that would not reflect the will of the people. Then, your lordships, my lord, kindly come to page, my lord, I'll just read, my lord, at page 24, that is 29 foot. My lord, it's a constitution bench judgment and only the highlighted part at page 29, my lord. 25, my lord, PDF 29. The court also needs to be mindful that a legislation does not become unconstitutional merely because there is another view or because another method may be considered to be as good or even more effective, like any issue of social or economic policy. It is well settled that the courts do not substitute their views on what the policy is. But my respectful submission is policy throughout all legislations, including Special Marriage Act and Hindu Marriage Act, is recognition of marriage as a socio-legal institution between heterosexual couples. That policy can be reviewed, reconsidered, and redecided by the Parliament, having, my lord, after having wider consultations and, my lord, after gathering all the facts, gathering all possible scenarios which need, my lord, to be regulated. Now, your lordships, my lord, come to page 26, my lord. 20, that is 30, PDF 30. First unnumbered paragraph, my lords. Does my Lord Justice Bhatt and Justice Kaul as well?
Dogs.
Yes. May I read, my Lord, with my Lord's permission?
Yes.
Your Lordship gets one. My Lord, the Chief Justice gets one.
Page 30, right?
Yes, PDF 30, my Lord.
Yeah.
First unnumbered paragraph.
Yes.
This understanding has also come to be judicially accepted even in the United States, which had earlier permitted same-sex marriage by judicial decision. The United States Supreme Court, in Dobbs versus Jackson Women's Health Organization, has held that fundamental rights must be objectively, deeply rooted in the nation's history and tradition. Justice Clarence Thomas, in his concurrence in Dobbs, noted specifically that this meant that the court should reconsider Obergefell versus Hodge, which 5-4 permitted same-sex marriage by a judicial verdict, in which the Supreme Court, by a judicial order, granted recognition to same-sex marriage. Further, the majority led by Justice Alito in Dobbs' case was emphatic in what it referred to as usurpation of power by the court and held that the issue be returned to the elected representatives. After doubting Obergefell, which permitted same-sex marriage. And in Dobbs, they say we send it back to the elected representative, namely the Senate. Lord, please read, my Lord Justice Alito. Roe, my Lord, that is Roe versus Wade, my Lord, your Lordships are aware. Roe was in collision course with the Constitution from the day it was decided. Case perpetuated its errors, and those errors do not concern some arcane corner of law of little importance to the American people. Rather, wielding nothing but raw judicial power, the court usurped the power to address a question of profound moral and social importance that the Constitution unequivocally leaves for the people. Case described itself as calling both sides of the national controversy to resolve their debate, but in doing so, Case necessarily declared a winning side. Then again, my Lord highlighted the underlined part. Put aside the second and third factors, which were based on the court's flawed account of history, and what remains are precisely the sort of considerations that legislative bodies often take into account when they draw lines that accommodate competing interests. The scheme Raw produced looked like legislation, and the court provided the sort of explanation that might be expected from a legislative body. Lord, reasons which the petitioners urge are the reasons which can be given, accepted, rejected by the Parliament. Our decision returns the issue of abortion to those legislative bodies, and it allows women on both sides of the abortion issue to seek to affect the legislative process by influencing public opinion, lobbying legislators, voting, and running for office. Neither decision has ended debate over the issue of a constitutional right to obtain an abortion. Indeed, this case, 26 states expressly ask us to overrule Roe and Casey and to return the issue of abortion to the people and their elected representatives. The states were before the court. So out of 51, 26 said that you overrule this. Return it to us. It's our domain. This court's inability to end debate on the issue should not have been surprising. This court cannot bring about the permanent resolution of a rancorous national controversy simply by dictating a settlement and telling the people to move on. Whatever influence the court may have on public attitudes must stem from the strength of our opinions, not an attempt to exercise raw judicial power. We do not pretend to know how our political system or society will respond to today's decision overruling Raw and Casey. And even if we could foresee what will happen, we would have no authority to let the knowledge influence our decision. We can only do our job, which is to interpret the law, apply long-standing principles of stare decisis, and decide this case accordingly. We therefore hold that Constitution does not confer a right of abortion. Raw and Casey must be overruled, and the authority to regulate abortion must be returned to the people and their elected representatives. We end this opinion where we began. Abortion presents a profound moral question. The Constitution does not prohibit the citizens of each state from regulating or prohibiting abortion. Raw and Casey arrogated that authority. We now overrule those decisions and return that authority to the people and their elected representatives.
Mr.
Now, my Lord,
Mr. Solicitor,
yes, ma'am.
these judgments which you have cited on the limits of judicial power, that principle of law is well settled. I mean, there's no question about it, that judges don't legislate. The power to frame law, to look at the myriad different social complexities, is entrusted to the legislature, whether at the center or in the states.
Yes, ma'am.
That principle is a well settled principle. But if you are relying on Dobbs to support that principle, then we have gone far beyond Dobbs in India.
I know, my Lord. I know. I am going to cite your lordship. Yes.
Dobbs represents a view of the American Supreme Court that a woman has no bodily control over her own bodily integrity.
I'm not.
This theory has been debunked long back in our country.
Correct, my Lord.
So therefore, I mean, you're citing the wrong
lordships have
judgment.
referred.
You're citing the wrong judgments in support of the principle.
Lord, the principle is that the issues concerning moral or social implications be returned to Parliament. That's the limited point.
Fair enough. But don't cite Dobbs, because we have gone far beyond Dobbs here. And fortunately so.
Lord, Dobbs have cited.
I think we can at least credit ourselves that, we are far ahead of our times than many of the Western countries in that.
I am never a fan of, my Lord, citing foreign judgments. My Lord,
and certainly not Dobbs.
No, my Lord, I would say none. But, my Lord, not Dobbs. I understand. My Lord, Dobbs, we may have an issue, my Lord, even I have a personal issue with the subject matter it dealt with. We are not concerned, my Lord, with the subject matter Dobbs dealt with. Abortion is a right of autonomy of a woman. I'm not on that question at all. I'm on the principle which it laid down.
For instance, our law granted only to a married woman the right to obtain an abortion between 20 and 24 weeks. We dealt with that restriction. When an unmarried woman came before us and said, well, I must assert an equal right to an abortion. And we upheld that right, saying,
my Lord, I'm at the cost of repetition. We have
gone far beyond. I mean, much of the recent jurisprudence, on Dobbs and the overruling of Roe versus Wade.
I am at the cost of repetition.
Said on this jurisprudence, actually.
Lord, at the cost of repetition, I say, Dobbs is not relied upon for what it decides on the facts of that case. That we have proceeded much further, and we have always been much ahead of America or any Western countries in every which way. Unnecessarily, we follow the
principle that on complex social and moral issues.
That's the only limited ratio which I am relying upon.
Therefore, and legislature, that point is well taken, but not.
Yes, that's the limited point. My Lord, I am not supporting, my Lord, the judgment on abortion rights, my Lord. I am obviously, your Lordship knows, my Lord, everyone has a problem with that. But question is, when it concerns a debate, when it concerns social implications, return it to the people's representative. That is one reason. Second reason, my Lord, this Obersfeld is doubted here. which petitioners have relied upon. Look, that is one reason. Lord, forget the abortion part of it. I'm not supporting that judgment. But I'm nobody to support or oppose that judgment. I am citing it only for this limited purpose of showing that this is an issue which must be first reflected, debated, discussed, and my lord, decided by the parliament. That's the limited purpose. But please see, my lord, Justice Clarence Thomas, my lord, my lord, only highlighted part, only underlined portion. Forget, my lord, the this abortion part. I'm not on that, my lord. I also, my lord, do not agree. Your lordship's judgment in, my lord, termination of pregnancy takes care of it. I'm not on abortion at all. My lord. That's fact specific. But while dealing with some facts, when your lordship lays down the ratio, I cite it. This is
Fair-
the ratio.
Fair enough.
My lord, please see, my lord, only highlighted part. My lord, Obersfeld versus Hodge. My lord, your lordship gets, my lord?
Yes.
My lord, concurring view of Justice Clarence Thomas. For that reason, in future cases, we should reconsider all of this court's substantive due process precedents, including, then, my lord, they inter alia. My lord, I'm not reading all, but, my lord, even this Obergefell.
But going by this logic, we would be reconsidering the entire line of our precedent from Manekar to Shaira, which is not your submission also.
It's not my submission. It's not my submission. But my submission is, my lord, the last part of Justice Alito.
Yes.
Social implication, return it to the parliament. That's it. My lord, now, my lord, I have given the table. My lord, I'll read, my lord, those judgments a little later. But please come to page 29. I'm sorry. Go ahead.
Yes.
I'm sorry if I. My lord, page 29. My lord,
Yes.
I have compiled for your lordship's assistance, my lord, two things. The
Yeah.
countries where same-sex marriage is permitted.
Yes.
And I have bifurcated them that except with the 2 or 3 exceptions that came from legislature and not by the judicial pronouncements.
Right.
Number 1. Number 2. Lord, as I have pointed out, this is not something crucial. Lord, when your lordships recognize something or the legislature recognizes something, it will have impact on other laws, which I will demonstrate. Wherever the legislature has stepped in whichever country's jurisprudence, they have correspondingly amended other statutes, which only parliament can do. None of the other statutes are in question before your lordships. So the suggestion of the petitioner that keep the threads hanging, that is not permissible. But that is taken care of by various statutory amendments by various
Let's have a quick glance at these.
Well, kindly have,
Post
Lord.
legislation.
Endora, my lord, by legislature. Then, my lord, I'll just, it's a, my lord, translation. It was originally, my lord, we got it translated. It's a Google translation. I must, my lord, at the outset put a caveat, my lord. There may be, generally, it's not, my lord, much of discrepancy, but maybe some lacking in accuracy. Marriage contracted in civil form has the same requirements and effects, whether both contracting parties are people of the same or different sex. This is what, my lord, the new statutory regime brought by the legislature says. But what is important is legislature made following consequential changes. The Amendment Act of February 2023 amending the following provisions: Article 77 of the Family Code on forms of marriage, 78 of the Family Code on effects of civil and canon marriage, Article 91 on civil consequences of entering into a canon marriage, and Article 244 on the competence of Andorran authorities to celebrate civil marriage. Maybe some local requirements there. But the point is that whenever legislature does it, it applies its minds and makes corresponding changes. Then Argentina, by legislature. Translation: marriage will have the same requirements and effects regardless of whether the I'm sorry, my lord.
Yeah.
My lord, possibly, my lord, Justice call is on mute, my lord, if your lordships are asking me something.
No, no. I am right there where you're reading it.
Oh, I'm so sorry. I thought my lords are putting some
I
question.
was putting a question. I was trying to put a question,
Yeah, I'm so sorry, my lord.
rather a suggestion. Instead of reading the whole lot, I think this is a chart which segregates, say, puts a classification.
Correct.
And out of the 34, there are 34 countries. Of that, 29 countries have straight away legislated.
All of them.
And even the legislatures are done in a graded manner.
Correct, my
And
lord.
in 9 other cases, these legislations have been preceded by some court directions or decisions.
Reverse, my lord. It's converse. If your lordships comes at page 42, that is 46, my lord, PDF 46, I have given. My lords may, my lord, come to page PDF 46. Your ladyship may see, my lord, I have given same.
Legislation is the legislative process. 24 countries
Correct.
where the recognition was through a mixed process initiated
Process
by the legislature.
initiated largely by legislature or executive.
But
Then,
there,
my lord,
South Africa is one
the court
exception.
stepped in.
South Africa is the exception in that sense.
Yeah, yes.
But then I think you have also to take into account Taiwan, Taiwan and Austria.
Yeah, I know, my lord, but kindly turn the page over. Kind,
Yes.
No, I'm sorry, my lord. Taiwan, please see, my lord, page 41. My lord, that is 45 PDF.
Yes.
I'm going to, my lord, read, my lord, Taiwan Supreme Court also, my lord, where the dissent also will be illuminating, my lord, to your lordship. My lord, mixed process. Taiwan, your lordships have, my lord?
Yes.
My lord, Justice Butt and Justice Call has, my lord?
Number
Yes.
31.
Number 31, yes, number 31. Mixed process. From 2015 to 2017, several municipalities, local governments of Taiwan, like so and so, so and so, so and so, allowed registration for same sex marriages and allowed civil union of sorts. In 2017, the Ministry of Interior formally asked all local governments to open registration for same sex couples. It was after the said legislative or executive process that in Judicial Yuan Interpretation number 748, the Constitutional Court further expanded rights to allow formation of permanent unions to include same sex couples. It
And now
started initially by legislature, then executive stepped in, and then the judgment, my lord, of
now you have the law, I think, in 2019.
yes, my lord.
And even in Austria, now let's see, because Austria is one case which was given, which is shown to us.
My lord, page 34, your lordship would get. My lord, the chief justice, 34 PDF. 34 is Austria.
Yes. Now, what is the position? Even there, it was
Yes.
followed by legislation.
Yes, my lord, legislature provided for registered partnership for same-sex couples in 2010. The relevant provision in section 3, my lord, translation, a registered partnership can only be founded by two people, registered partners. In this way, they form a long-term partnership with mutual rights and obligations. Role of court. In January 2013, the Constitutional Court ruled that the registered partnership law was partially unconstitutional, broadening the rights of registered partners. On 4th December 17, the Constitutional Court struck down the ban as unconstitutional, ruling that preventing same-sex couple from marrying violates the principle of equality and non-discrimination. Lord, Lord, there was a prohibition which came to be challenged. Lord, as therefore, my lord, I started by
As
saying,
in the case of Windsor.
yes,
As in Windsor. Windsor also the prohibition was challenged.
because there is, your lordships are not, my lord, confronted with a situation where there is a law prohibiting same-sex couple, my lord, marriage.
The UK was a situation where they first recognized by a law civil partnerships in 2006.
I think
And
that
thereafter, 7 years
2004.
later, they enacted the
2004.
Marriage Act.
Yes.
UK is very interesting. You might read
Yeah.
that.
You just see the UK actually, your page item 32
Yes, madam.
at PDF 45.
Yes, madam. I'll just
Because you
United Kingdom.
remember, Gaidan was 1999 or 2000.
Lord, Gaidan, my lord, was, my lord, cited out of context, my lord, and I have, my lord, given a detailed note on Gaidan in this.
Mr. Solicitor, just keep ourselves to this because Gaidan was in some other context. One realizes That was in the context of a tenancy where
One, my lord, Rent Act was in question. That apart, even there is another, my lord, fundamental foundational distinction, which, my lord, I'll come to, my lord. But please see item 32 by legislature.
and that
Civil Partnership Act 2004 came into effect in December 2005.
Actually, in the context of of a tenancy, the real principle is of settled residence. So the law gave protection to the surviving spouse of an erstwhile tenant. Why is that protection given? We also have it in our Gyan Devi Anand, that whole line of cases from the Constitution bench. The idea is that when a tenant dies, anybody who's in settled residence as a member of the family should also be entitled to the protection of tenancy, which is otherwise a heritable asset. That's the principle.
Correct. My lord,
Gaidan also said the
separately,
same
my lord.
thing, that, well, if you have a same-sex couple, even though the statute doesn't recognize a same-sex surviving spouse, the principle we they adopted was, the principle is really that of a settled residence. And the idea is to protect, as a matter of social welfare, one of the occupants of that particular tenancy, then that should not be deprived to a same-sex surviving spouse.
Yes, your lordship, sir, that was the fact. But, my lord, forgetting the fact, the principle which was relied upon was fundamentally flawed, my lord, and that's my separate argument. Why, my lord, Gaidan would not apply in the Indian context.
Just read now 32 at internal page 45.
32, my lord, I was at 32. United Kingdom, the Civil Partnership Act 2004 came into effect in December 2005. It created civil partnerships which gave same-sex couples who entered into them most of the rights and responsibilities of marriage. Thereafter, the Marriage Act 2013 for
Mr.
England and Wales.
Mr. Solicitor, this act, you described it in a very classical form, but actually that resulted in amendment to a lot of other enactments in 2004 itself.
Yes, my lord, your lordship would find that at PDF 549. My lord, volume 5 of our compilation, PDF page 549. 2013 Act, my lords, we have placed them on record. Place that act on record. That is marriage within bracket same-sex couples bracket over Act 2013.
So that resulted in an amendment to various other enactments.
And
that
then
is also,
and then 2013 led to a series of amendments thereafter.
Correct, my lord. That is also, my lord, part of that, my lord. I'll come to that, my lord, after showing this. Because right now this chart was only for the limited purpose of showing that it initiated by the legislature, except in case of, as my lords have rightly said, my lord, Taiwan and Taiwan also not fully, but South Africa. And South Africa, I have mentioned, my lord, at page 43, my lord, that is 47, PDF 47. Now, your lordships gets, my lord, at the top, my lord, the Chief Justice gets, my lord.
Yes.
Possibly the only country subject to verification, but we tried our best to verify. South Africa is the only country where the process was first initiated by judiciary and then followed by.
Which is Furi's case. Furi, which was read out by Mr. Grover.
Yes, my lord. Then, my lord, countries where civil unions are legal. That also, my lord, we have given. But I'm not going one by one.
No, we'll just only look at the headings of the. Yeah, and if we come across, any one of us comes across something interesting, we can pause there.
There are some mixed processes.
Yeah, my lord. For example, Bolivia is by judiciary. Because, my lord, Second Constitutional Chamber of La Paz Department Court of Justice, citing advisory opinion number so-and-so, issued by the Inter-American Court of Human Rights, ruled in favor of the couple recognizing same-sex civil union. However, it may be noted that several bills had been introduced in the country's legislature seeking recognition, and the political debate was ongoing on the said issue.
Look at Latvia. Something very interesting happens in Latvia at item 9.
Yes, my lord. By judiciary first, thereafter legislature. Latvia does not recognize same-sex marriage, but same-sex couples are able to register their partnerships with the government through the courts. On 12th November 2020, the Constitutional Court of Latvia ruled that the Latvian constitution entitles same-sex couples to receive the benefits and protections afforded by Latvian law to married opposite-sex couples and gave so and so until 1st June 22 to enact a law protecting same-sex couples. My lord, that may be, my lord, as per their constitution. My lord, your lordships never issue a writ to parliament.
A lot of countries, of course, we don't follow that model, Mr. Solicitor. I mean, we are now discussing at a theoretical level. Some countries have followed this doctrine where the judiciary say we give you 3 months to take steps to enact law, for instance, so 3 years or 1 year or whatever. If you don't, then this will follow. So Latvia seems to have followed that.
Followed that, my lord, but that, my lord,
no, I began by saying that we have not, we scrupulously say no
your
no
lordships
mandates,
have always, my lord,
mandates to parliament.
scrupulously, my lord, never issued
But
writ.
there are countries which follow that, well,
Yes.
we declare the law, we give you so much time, put the law in order.
Depends upon the constitution. Like, my lord, in Great Britain, the parliament is completely sovereign. My lord, there is no power to declare the law unconstitutional, etc. My lord, that depends upon the constitutional culture, as I say, my lord. But our, my lord, constitutional position has been consistent, my lord.
Let's scroll down.
Then, my lord, summary is at page 49 PDF. Civil union position. Then countries where civil union or a partnership arrangement is given recognition, 16. Countries where recognition was through purely legislative process, 13. And country where process was mixed, 3. Number 98. Therefore, it is clear that societies and countries have acted only after the said concept has gained currency or acceptability in their respective jurisdictions, and the elected representatives have acted on the basis of locally prevailing ethos, beliefs, and understanding of marriage or civil unions. It is submitted that, therefore, there was a clear and direct democratic mandate behind the recognition of same-sex marriages in which ever jurisdiction such relationship were recognized.
Mr. Solicitor, if you don't mind, can we now just skip a little bit and go to page 54? Let's now go to the heart of the matter, which is the legislative intention behind this, because you've given us a flavor now.
Yes,
Substantially gone through your, isn't
would
it?
your lordships, my lord, consider coming to page 50 instead?
Those judgments which say about legislative policy and other things,
Yes,
those you've given them to us, and it's very well basic doctrine. I don't think we need to read it together. Prim
your
grana
lordships indeed.
and
My lord, the proposition is
and everything. Yes.
some of them are constitution bench judgments. That's all I wanted to highlight. And my lord, the purpose, as I pointed out yesterday, was that I'll quote the paras rather than burdening the volumes, my lord, so that your lordships can immediately.
Brother Call and Brother Bhatt are not here. I don't online. They're online. I think those judgments at page 50 to 54, we need not spend time going through them, right? This basic doctrine, so they're well known, so we can just maybe look at them and go to the real.
Legislative intention behind Special Marriage Act.
I think yes, exactly. We'll go straight to page 54, I think.
Your lordship, sorry, page PDF page 54. My lord, the
Not to
purpose
say
is
that those judgments are not relevant, but there's just they're so basic that I don't think we need to spend time reading through them. That's why.
they're settled positions your lordships are fully aware of. This is just, my lord,
Let's
so that
see now how you've formulated at page 54 PDF.
yeah, my lord, 54, my lord, I'll just put, my lord, two propositions. Why, my lord, I am going through the debates. It might at some time, my lord, appear to be a little irrelevant, but please go through it. My lord, this is the debate when Special Marriage Act 1954 came to be enacted for two purposes. A, the intention was heterosexual, intra-faith, but heterosexual.
Just 1 second.
I'm sorry, interfaith, not interfaith, intercaste, but heterosexual.
Religious and irreligious, or no religious.
Yeah, yeah, yes.
It's only distinction between
Actually, it was religion neutral.
Correct.
The SMA was intended to be religion neutral,
Yes.
I would, my lord, nothing turns on that, but just academically, my lord.
Idea was because to create a platform where couples were not going to marry within the fold of their personal law.
The faith.
That, in that sense, religion
I'll
neutral.
just, my lord, just academically, nothing, my lord, may perhaps turn on this. Uh, even if I accept that it's a secular law or a non-religious law, my lord, it has taken some concepts of uncodified Hindu law, for
Of course,
example,
it does prohibited relationship.
degrees of prohibited relationship. That is Sagotra and Sapinda relationship.
Absolutely.
But in the format of, my lord, a religious or a non-religious statute. Some concepts, my lord, are there. Degrees
The whole
of
object was to permit two couples, two individuals who profess different faiths to have a
two different
to allow.
individuals of opposite sex.
That's what we are now considering. But the idea was basically it was to allow two people who did not profess the same religion to have.
Or maybe the same religion, but different castes.
Correct.
Correct, you are right.
Because section 21A, my lord,
That's why Arundhati referred to the caste disabilities
Yes,
Act
yes.
and other things.
Dr. Ambedkar piloted this bill, and this is before
the reason was, my lord, your lordships have been shown, my lord, by Ms. Kaju. Lord, it was earlier 1872 law, where if I marry under that special marriage act, I have to denounce my religion. So therefore, my lord, that was brought back by 21A.
21.
Mr. Solicitor, you'll not be completing tomorrow, today. So tomorrow when you resume, maybe if one of your juniors can do a little exercise taking from the table which Ms. Kaju has prepared.
Yes, yes.
And give us a 2-page note or 3-page note on the antecedents of the SMA.
Yes, yes.
Just take, you'll get the material from that note and just sort of develop it into a 2 or 3-page note for us tomorrow morning.
To some extent, my lord, I've set out some of the materials of the debates and so
Right.
on in the additional compilation which I had filed.
Do we have the statement of objects and
Yes,
reasons?
we do. So which refers again to.
No, debates also mentions that. My lord, there is
Well,
a
let's
flavor
do that page
in the debate.
54.
Well, the
Page-
second point, my lord, your lordships may bear in mind. My lord, it was argued that in 1954 there was no concept of gays, etc., and therefore obviously there was no mention. Your lordship, my lord, that was Mr. Rodgi's submission. My lord, my respectful submission, my lord, and I'll take your lordship to that, are twofold. A, even if that is so, that is no ground for the court to rewrite and include something not intended. B, they were aware of it. There is a discussion on that. And therefore, I'm going to respectfully submit that there is a conscious omission. That's one more reason why it cannot be read into. Lord, may I read, my lord? This, my lord, I may read a little, my lord.
Yes, that's
slowly.
right.
105. At the outset, it may be noted that if the principle canvassed by the
Just one
petition,
second. Is that page,
I'm sorry,
Page 50.
it is 54
Same
PDF.
volume.
54. Okay.
Yes.
Lord, its title is Redrafting Exercise of Special Marriage Act, your lordship gets. My lord,
Yes.
Justice Narasimha gets. Yes. At the outset, it may be noted that if the principle canvassed by the petitioners, that word man or woman or other phrases representing the two opposite sexes are capable to interpretation in a gender neutral manner, it would open up a whole host of statutes and provisions to constitutional susceptibility. My lord, your lordship can skip that. 106. As far as the present case is concerned, the debates in Parliament during the framing of the Special Marriage Act and the Hindu Marriage Act 1956 are illustrative in this regard. The said debates clearly identify that the entire architecture of the statutes was premised on opposite sex marriages and the provisions surrounding the legal recognition of marriage, the succession amongst children, and other aspects, as are all completely premised on the legislative presumption of opposite sex marriages. The Parliament was aware of gays and lesbians even in 1954. However, it is clear that the Parliament took a conscious call of not mentioning them. It is interesting to note that the Select Committee on the Special Marriage Bill 1952 approved Section 4 of the bill in a form which did not use the word male or female and rather use the word parties. The clause is quoted as under, my lord, as per Select Committee. The parties have completed the age of 18 years. Each party, if he or she has not completed the age of 21 years, has obtained the consent of his or her guardian to the marriage. This is substantially what they want, my lord, to reinterpret. It was after a heated debate going on for days and days that Pandit Thakurdas Bhargav brought an amendment that provided for separate ages for boys and girls in the form of 18 years and 21 years. It should be reverse. Boys and girls respectively 21 years and 18 years. It is submitted that apart from the above, the debates clearly show the limited purpose behind the enactment and the clear, unequivocal understanding of marriage as an institution between opposite sexes. The speech of learned Minister of Law and Justice at the time, Sri Charan Chandra Biswas, is illustrative in this regard. The relevant portion of the debates are as under. Then Sri Biswas. Let me now refer specifically to some of the salient features of the bill. The first is, as I have already pointed out, marriage under this law will not require the parties to forswear their religion or to declare that they do not belong to any religion. Any two persons residing in India will be eligible to marry under the provisions of this law. It is permissive, no doubt, but it is compulsory only to this extent that if they marry under this law, the conditions herein laid down must apply. They must make up their minds as to whether they wish to be subjected to these conditions. If they do not choose to be subjected to these conditions, it is open to them to discard this and to marry according to the law which now governs them. That was, my lord, personal uncodified law, which does not prohibit LGBTQ plus marriages. Yes, except, my lord, in case of LGBT. Yes, my lord, Hindu Marriage Act prohibits. Yeah, my learned friend is right. My lord. The Act of 1872 applies to two categories of persons. Firstly, to persons who do not profess any of the major religions of the country, and secondly, to persons who profess the Hindu, Buddhist, Sikh, or Jain religions. The result is that this act does not permit any interreligious marriages unless the parties are prepared to forswear their religions. If they are Hindus, then both of them must be Hindus. If they are Buddhist, both of them must be Buddhist. If they are Sikhs, both of them must be Sikhs. And if they are Jains, both of them must be Jains, in order that they may marry under the Act of 1872 as it stands now. For the first time now, we are going to do away with all distinctions based on religion. The bill, if passed, will permit of interreligious marriages. Religious differences are put out of the way altogether. Government feel that the time has now come when religious differences should not stand in the way of a couple getting together. If they feel that their lives are cast together and the fact of their marriage should not in any way affect their religious belief, that is the main change. This is the legislative intent, my lord. Now, Mr. Sri Biswas, my lord, the underlined portion. Under the provisions of the original, I may read, I'll read the underlined portion. Under the provisions of the original act, none of the parties to the marriage could belong to any of the recognized forms of religion mentioned therein. Now, two persons, if they belong to the same religion, will be allowed to marry. But this privilege is confined only to Hindus, Buddhists, Sikhs, and Jains. That is because the main rights which were secured by this act were monogamy and divorce. The religions which were excluded already provided for monogamy and divorce. The Christian Marriage Act is monogamous and divorce is permitted. Muslims also have the right of divorce, though it is not monogamous. Kindly, my lord, turn to the next page. Lord, nothing may turn, my lord, on other debate. Srimati Reena Chakravarti, Mr. Deputy Speaker, sir, I do not propose to answer various things that have been said just now because I feel it is very difficult to answer people whose mind still remains in medieval times. It is even more difficult to convince anybody who thinks that he himself has the monopoly of all morality and everybody else who demands progress seems to be having some problem with someone, as we can read between the lines. Himself was the monopoly of all morality and everybody else who demands progress immediately should be dubbed as irreligious. We support this bill because the principles underlying this bill is progress. The entire idea is to have contractual form of marriage without the necessity of repudiating religion, which was necessary in the bill of 1872. This is the spirit, this is the heart and soul of the Special Marriage Act. My lord, next, my lord, speech by Sri Biswas, the Honorable Law Minister, is just to show that it was not a Brahmo Samaj oriented or Brahmo Samaj inspired piece of enactment. The Honorable Minister says that Brahmo Samaj, of course, is one of the major my lord, contributing factors, but not the sole contributing factor. Now, kindly come to my lord 57. PDF 57, my lord. My lord, at the third unnumbered paragraph, Sri Biswas. I was just going to read from the Act of 1872. It's, my lord, it can be avoided. My lordships may come to
58.
at the foot on homosexuality. Your lordship gets, my lord?
Yes.
At the foot, my lord, there is a title. This is debate dated 6th of September 1954. See, Raghava Hari, Penukonda. I do not wish to take up much time from the arguments that have been advanced for straying away from a thing that has been recommended by the other house. I am not satisfied that there has been a fair or a clear approach to the matter, but only there is an attempt to confuse the issue. One thing that I find is that this act was meant to afford an opportunity for advanced people with reformed ideas and people who are economically independent and have their own judgment, mature judgment about their course of action for the future. It is only for such people that this Special Marriage Act was intended. In the course of their arguments, members have been urging that the marriage age in the country should not be high, that is too old an age, and that therefore more people cannot come under this act. 21 and 18 was considered to be too old, my lord, in those days. It was also stated that this was only a permissive legislation to people who want to take advantage of it if they are in position to understand what they are about. You will see that the whole thing, you will see that the whole thing is made topsy-turvy. The idea was that the people who have attained a certain age, when they can make up their minds, nobody should interfere with their judgment. Now you want to reduce the age and put in a guardian. Why this spoke in the wheel? You know that this is permissive legislation, that marriage can be permitted between a person of one sex with any other person who is of other sex. This is what they understood, my lord, throughout. That is the heart and soul running, my lord, through the debate, irrespective of caste, community, religion, anything. Then you want to introduce the element of a guardian's consent. Do you expect that the guardians are more advanced than the present generation, which want to marry without the guardian's consent? I am afraid this guardian's consent for marriage between people, which you are introducing, is going to be the cause of all that ineffectiveness of the legislation. Then Dr. Jayasuriya, I beg to move in page 9, line 43, after sodomy, insert with her homosexuality. But sodomy was a ground for divorce. He said, insert this also because this is prevailing. It would come. That this is now quite prevalent. Mr. Iyengar, notwithstanding the fact that prohibited degrees have been brought down, I do not know whether the next generation may not say that a brother can marry a sister. According to Mandal's law, the idiosyncrasies of parents among animals will persist or generations. My friend Dr. Jayasuriya will support me in this. Is this law to be ignored in case of men? A man must marry only a woman. He cannot marry a man. Is this all that counts? Then, my lord, on marriage between opposite sexes, Mr. Achyutan, I agree with that viewpoint. The girl and the boy must have sufficient maturity, sufficient age growth to understand the consequences by which they will be tied when they marry under the special law. So there is no necessity, no special ground, no coherent ground for saying that it must be reduced to 18. Moreover, according to me, why marriage means early responsibilities. There might be a sexual feeling, patience which will be there and all that. We must try to restrain them. According to me, youngsters cannot think of marriage before 25 or 22. It is not simple matter. It is a serious thing, so that the age limit must be at least 21. There cannot be any reduction either in case of the boy or in case of a girl. Again, my lord, they were talking of opposite sexes. And Mr. Deputy Speaker, my lord, Mr. Chaudhary. Your lordships may, my lord, kindly come to, my lord, the bottom. My lord, kindly, no, my lord, just third para, my lord, from the top.
The floor of the house can't really.
At that time, solicitor,
Yes, my lord.
were there laws permitting same-sex marriages anywhere else in the world? I think
Not to our knowledge, my lord. There was no prohibition, but not to.
even in England there was a prohibition. Till
Hmm.
73, I think it was prohibited. So there perhaps was no platform, no legal foundation for a marriage or a marriage like you recognized by law when this was all debated.
Your lordships are right, my lord. Possibly in India also, my lord, till 56, when it became man and woman, bride and bridegroom, there was neither permissive nor prohibitive. That Shastric law, my lord, that uncodified Hindu law would apply, my lord, that may have, my lord, repercussion. My lord, page 59, PDF 59, the third from the bottom, Srimati Amu Swaminathan. Your lordship gets that, my lord. I rise to support the amendment moved by Pandit Thakur Das Bhargav, which provides that the man has completed the age of 21 years and the woman the age of 18 years. Now, my lord, what my learned friends want us to read is a person has completed the age of 21 years and a person has completed the age of 18 years. We do not know, my lord, which person, who is man, who is woman. We do not know. Unless we destroy the structure and fabric, my lord, it would not be possible to read the way, my lord, the petitioner want. Srimati Da Pala Chaudhary. I shall be still briefer than the one who have gone before me. I fully support the amendment of Pandit Thakur Das Bhargava because it is quite right that girls of 18 and boys of 21 should be allowed to marry. Then Pandit K.C. Sharma. I am rather surprised at the arguments of my friends both supporting this bill as well as opposing it. It is simple measure. In this country, in the Hindu, Christian and Mohammedan religions, marriage is predominantly governed by personal law, and these are rules of conduct or for the husband and wife in all these religions. Then cases had happened when marriages were to be performed and the people did not belong to these religions. So in 1872, a law was passed, the Special Marriage Act, under which certain people who did not belong to certain religions could perform their marriages, and the basis of the marriage was contractual. That is, as human beings, the young man taking the young woman as wife and the young woman taking the young man as husband. When they took each other as husband and wife, it did not follow that they said goodbye, as Mr. Nandlal Sharma said, to everything decent in human life. That is not the question. The words husband and wife are significant words. There are certain implications, a certain significance, a certain meaning behind them. And the young man and the young girl who took each other as husband and wife undertook to observe the law of decency and good conduct in the society. It cannot be said that because they married beyond the Hindu, Muslim, Christian, or any other religion, therefore they said goodbye to everything that was good in those religions. That is not the point. For my friends' information, I may say that even in the Rig Veda it is stated that you, the young girl, go to the youngest man, be thou mother of heroic children for the good of the society. The good of the society means the good of the race. Therefore, the emphasis is not on the performance of yajna as such. The emphasis is on looping the thread of the race alive. What is important is the progeny. Therefore, the emphasis lies with regard to the race, not with regard to the religion. The contractual form, I may again mention, is not doing away with everything ethical or decent in life. The simple difference was the sacramental forms were done away with. That a Hindu was not required to go 7 times round the sacred fire. But it does not follow that because he has not gone round the sacred fire 7 times, therefore everything that was said before the sacred fire was not in the mind of the girl or boy. They say, we observe, my lord, so and so, and last line, under the proposed bill, any Indian citizen can marry another Indian citizen, of course, of the other sex. Now, your lordships would find this debate was simultaneously going on with regard to Hindu Marriage Act also. It was, my lord, a composite, comprehensive, my lord, exercise which was being done. And having the similar provision on sodomy. My lord, please come to, my lord, the bottom. On 20th December 1952, my lord, the relevant would be, my lord, yes. Lord, 59, my lord, kindly come to 59. That would be 63, PDF 63. Lord, page 59, but a PDF would be 63. My Lord Justice Call and Justice Bhatt gets, my lord.
PDF 63.
The Honorable Chief Justice, my Lord Justice Narsip. I'll just read at the foot, my Lord, Sri S.
This
Mahanti.
is relating to Hindu Marriage Act.
This is debate of Hindu, my lord, it was simultaneously going on. Same people, same members, same provision in, my lord, question, but your lordships are right, factually, Hindu Marriage Act.
100. No, 60. PDF 60 it starts.
Your lordships are reading some.
Even the dates also are similar.
Triple one.
Yeah, yes, my lord, dates are relevant. But this is 20th December 1952.
Hindu Marriage Act.
And my lord, what we read was September 54. But it was a period during which all these, my lord, legislations came.
No, this is
No, no. As a historical fact, of course, it's the Hindu Succession Act and the Hindu Marriage Act would have been enacted by the first Parliament, not I mean
Yes,
the
yes,
first
my lord.
Parliament. The elections took place in 52. So
Correct,
this is
my lord.
provisional Parliament. So when it
Correct,
when it
correct.
took place, then looking at the nature of the Hindu Marriage Act, which came in 56, perhaps this was debated with when it was enacted becomes material. Maybe there was presidential, it is documented, no, historically. That
Lord,
the,
can I request your lordships, my lord, to see page 57 foot, the date on homosexuality. That is, my lord, 6th of September 1954. Your lordship gets, my lord?
yes.
Yes, it's there.
That is homosexuality in the context of Special Marriage Act. That's the debate which is going on. Then the next date is 16 September 54, 17 September 50, it should be 54, then 16 December 54. Then, my lord, on marriage between opposite sexes, again, my lord, 54. But if your lordship, my lord, comes to,
Why is 20th December 52 is mentioned against Hindu Marriage Act?
my lord, I think
That's not
my
the
lord,
date.
it was debated, my lord, for
Maybe.
yes, my lord, about 2 years.
2 years.
I think that's the reason. There was a lot of discord,
Started
no?
from, must have been started from 50.
I could not hear my lord Justice Bhatt, my lord.
Justice Bhatt is saying something.
I think there was a lot of
I could not.
discord. If I'm not wrong, there was discord about the Hindu Marriage Act. So
Yes.
perhaps the Special Marriage Act got enacted first. So the Hindu Marriage Act might have undergone a lot of debate. Ultimately, this was the point of difference between the president also, right? Which led to the Hindu.
Correct.
Lord, we'll check. I'll
Yes,
check
the
up
one
at
vote
this
of the
point because
president.
I don't wish to be inaccurate, my lord, in factual this thing. But if your lordship comes to 59, that is, my lord, 63, PDF 63, your lordship would find the debate dated 14th December 54. This is debate of Hindu Marriage Act, but the same provision of Lord divorce being considered.
Where do you want us to read, Solicitor? Now?
Mr. Mahanti's
Hindu Marriage
discussion.
Act. Where do you want us to read?
Mr. Mahanti's discussion.
Yes, Sri S. Mahanti. Yes, sir. I shall be brief. I speak in support of the amendment number
One
135.
page.
I'm sorry, page 63 PDF.
Yes, got it.
At the foot, my lord. Last speaker is, my lord, Shri S. Mahanti.
Yes.
Yes, sir. I shall be brief. I speak in support of the amendment number so and so, which is a very innocuous one, namely that at page 8 for line 12 to 40, the following be substituted, namely, and by either spouse on the ground that husband or wife, as the case may be, has since the solemnization of marriage been guilty of rape, homosexuality, or bestiality. It will be apparent from the wording of this amendment, sir, that it only seeks to substitute one very obnoxious, though biblical word sodomy by word homosexuality. I can well anticipate the objection that the Honorable Minister in charge of the bill would bring forward against this amendment. He may point out that the term sodomy is one which has received wide recognition in the Indian Penal Code, and therefore we cannot substitute that word by another, namely homosexuality, however more scientific and appropriate that term may be. But I would submit that it has also to be borne in mind. I'm sorry. I would submit that it has also to be borne in mind that here we are not going to make sodomy a penal offense. Therefore, it has got no relationship whatsoever to the Indian Penal Code here. We are here discussing this question in isolation. So it has no relation whatsoever to the Indian Penal Code. Therefore, I hope my esteemed friend, the Honorable Law Minister, will have no such argument to offer while replying in me second place. There is no reason to believe that sodomy is only a masculine vice. I have not time, nor is this occasion otherwise. I could have quoted chapter and verses to show that homosexuality amongst women is also today on the increase, that it is on the rising scale. I have got whole literature on this with me. Then, my lord, they discuss. Then Mr. Mohanty says, yes, sir, I submit, instead of using the term sodomy, you should use the better and more appropriate and scientific term homosexuality. Then Sri Mohanty. But before I resume my seat, sir, I wish to urge this House not to take a Philistine attitude. I would request the Honorable Minister not to take any such prudish attitude regarding this matter. We are not moving this amendment in a sense of levity. On the contrary, if you want to contribute to the solidarity of marital life, if you want to contribute to a healthy married life, and if you consider that sodomy is one of the reasons which can render married life unhappy, then there is every reason why you should also include the feminine vice of lesbianism and substitute the word homosexuality for the word sodomy. That is my submission, sir. Then, my lord, ultimately, Dr. Karmakar, my lord, puts an end to the debate by this. As I said, for the time being, let us be content with the use of the word sodomy. If homosexuality becomes a problem, we shall face it courageously. Look, this was in the context of adding homosexuality as a ground for divorce. One was saying that homosexuality and lesbianism is on the rise. Please add it as a composite word. The minister says, let it remain sodomy. If it becomes a problem, we'll face it courageously. The purpose of, my lord, my reading the debate is that it's not as if they were not aware of other spectrum other than, my lord, conventional man and conventional woman. They discuss. Initially, they start with parties. Thereafter, they discuss. They know it cannot be parties. It can be boy and girl. Then they define separate age for boy, separate age for girl. They were aware of homosexuality, but they consciously avoided even as a ground of divorce. May I continue tomorrow?
We'll continue tomorrow. Mr. Solicitor, what is...
Lord, I have, my lord, we have prepared, my lord, for our on our side. Lord, I'm sorry, my Lord, maybe a day, my lord, 2 sessions, my lord.
My lord,
But
yes.
if it spills over, my lord, an hour or so.
All right.
But my learned senior, my lord, Mr. Sibal is there. Learned AG is, my lord, I think learned AG wants to say
Lordships
something.
will have to tell me when I wish to need to address your lordships.
Lord, my apologies to Justice Call and Justice, but my lord, I'm handing over the tentative timings suggested by all councils, but it's not, it's in physical form. I'll, my lord, ensure that your lordship gets it.
Solicitor, it will reach, don't worry.
Yeah, but I ensure, my lord, that it will reach. My lord, this is the period suggested by everyone. It is, of
The
course,
time we'll see how we'll best allocate. The first few council, of course, will give you a very substantial field for argument. The others, as in the case of the petitioners, will have to curtail their arguments.
My lords, yesterday, when I concluded my submissions, Honorable Justice Bhatt had asked for some documents. I just want to draw attention that I filed those this afternoon.
Yes.
obliged to, Lord.